University Bocconi, which is exactly from where I'm actually presenting. I flew back to Italy a few days ago for the SIEL, and also because I had my second dose of the vaccine. So first of all, I would like to introduce my fellow colleagues in order. I'm Professor Ann Peters, who is director of the Max Planck Institute of Comparative Public Law and International Law in Heidelberg, and he's a professor at the University of Heidelberg, Freie University of Berlin, Basel, and University of Michigan, at the Law School of the University of Michigan. Secondly, Professor Han van Aaken, Alexander von Humboldt Professor and Director of the Institute of Law and Economics at the University of Hamburg. Then Cecily Rose, who is Assistant Professor of Public International Law at the Grotius Center for International Legal Study at the Leiden University. Professor Kevin Davis, his Beller Family Professor of Business Law at the New York University School of Law. And finally, with a special thanks for internal reasons, Professor Yarik Kryvoi, who is a Senior Fellow and Director of the Investment Treaty Forum at the British Institute of International and Comparative Law. I will start by introducing our panel, and I will speak candidly. Over the past few days, not only I struggled with the technical tutorials of this forum, but I also was admittedly struggling to find an effective way to introduce our panel and convey its key messages. This was partly due to the variety of topics addressed by the outstanding contributions of my colleagues, but also by the inherent complexity of the issue that we're going to discuss. Then, a plain historical fact came to my mind, a trivial historical fact came to my mind, which is that in human history, if you think of it, the most different normative orders have consistently condemned corruption in its domestic variety. References to corruption as an immoral or illicit conduct can be found in the fundamental text of the most ancient cultures and religions also, and different religions, such as the Holy Bible. I counted just the Exodus book, Deuteronomy, Samuel, the Law of Manu, the Confucius and Buddha's doctrines, Plato's dialogue on the law, Christian doctrine, and of course also the second surah of the Quran, and of course political philosopher too, of different ages and different schools of thought, ranging from Aristotle to Machiavelli, Montesquieu, Jeremy Bentham, Thomas Hobbes, characterize widespread corruption as a mark of the collapse or the degeneration of a whole political system. And of course, we all know that bribery and other forms of corruption, what we would refer to as, at least today, the domestic variety of bribery and corruption, have been in the criminal statute books of many states for decades and centuries. And yet the fact remains that international cooperation against corruption, including the efforts to tackle international or transnational forms of bribery, has only begun as late as the 90s. In fact, it was only in the 1996 that the first international convention on the subject, the Inter-American Convention Against Corruption, was concluded. Other 7 international treaties soon follow, with the UNCAC, the United Nations Convention Against Corruption, the only multilateral treaty aspiring to have sort of global reach, adopted in 2003. So we have attempted, and that was our collective effort, to take stock of the first 25 years of international cooperation in the area of corruption, also with respect to its dialogical relation with the domestic legal jurisdiction of states, to offer, first of all, a critical assessment of its outcomes and possible way forward, meaning we look at the international cooperation against corruption, both retrospectively and prospectively. And to this respect, my role is honestly quite modest. I am only going to, that's tricky. Okay, it didn't share my screen. Sorry, it worked early on. Now it doesn't work anymore. I try once more. Share. now it works. So I was saying that my role is modest in the sense that I'm only going to set the stage for our discussion by showing to the audience and also to my fellow panelists the preliminary results of the data-driven analysis I'm conducting about the outcomes of the main anti-corruption treaty compliance mechanism. And this with the aim of, to show at least what has worked, where states have failed in the implementation of the main international criminal treaties against corruption. But one important point of the panel of our foregoing discussions is that, of course, international criminal law and international criminal law treaties against corruption are the central, probably, but not the only element of the international cooperation against corruption. However, to this end, I have actually selected 24 countries based on the fact they ratified all, or at least 3 of the main international anti-corruption conventions, which establish treaty compliance mechanism. And then I based the other criteria to select them on the state of economic development, geographical representation, and or the demography. Of course, despite the efforts, despite the difference in terms of sophistication, quality of the analysis, assertiveness of the result of the analysis, and also comprehensiveness, the treaty monitoring mechanisms report that I analyze are quite detailed, and certainly they are complex. It's quite complex to summarize the result, in a way that could be easily presented, visually easily presented today. So in order to achieve this result, what I've tried to do with these visual maps was to, first of all, analyze each and every report, also in the chronological sequence, meaning considering the different rounds for each of the country which were selected in my sample. And then, of course, I analyze the report and I make a number of informed decisions in order to summarize whether or not, for example, a certain key obligation of here we have the OECD Anti-Bribery Convention was implemented or not implemented, or according to the working group of bribery of the OECD was only partially implemented. And you have a similar analysis for the Council of Europe Criminal Law Convention on Corruption here. And I'm not going to dwell upon this data too much because of obvious reason of time constraint, but because these are, are meant just to be the trigger of our ongoing discussion. And I would like to leave, the floor to my colleagues. I would like just to summarize the result. And I must confess that when you cross these 3 conventions, and then for the UNCAC is slightly different, the picture that these mechanisms draw is quite consistent. Here I have a caveat. I needed to take out from a sample important states, one with is China, simply because China is party only of the UNCAC, and also because along with many other states, China did not consent to the publication of its report, but only of its executive summary, which is, however, the case of many countries. To make an example, also Germany did not consent to the publication of the first report that the UNCAC published. So to conclude, the result that we might actually found are that remarkably the treaty approach regarding at least criminalization has unquestionably contributed to calibrate the national responses, and in some cases, for example, the definition of the objective and subjective elements of the offense of transnational bribery in many legal jurisdictions, actually in virtually all domestic jurisdiction, the design of innovative sanctions such as the confiscation of equivalent and the promotion of forms of ex-criminal liability for legal entities, formulate them ex novo. And also the efforts of harmonizing the required elements of the different forms of corruption stand among, to me, analyzing these reports as one of the main achievements of anti-bribery treaties, as much as, is the widespread use of provisions of mutual legal assistance. Similar consideration can be also made in respect of the two breakthrough innovations of the UNCAC, one of which will be addressed by Dr. Cecily Rose afterwards, meaning the provisions on prevention and the provision on asset recovery. However, many problems, as it is also shown in the upper part of my slides here, remain, and these are manifest if we look at the two first columns here, the outcome of the UNCAC, which is formulated in a way. The reports are formulated in a way whereby it's different to make an informed result on compliance, non-compliance, or partially compliance. So I needed to choose another criteria, and for that reason I prefer to separate out good practices and challenges. You see that there are many challenges and these are just sample from the selected countries I include, but mostly I think that the challenges are actually emphasized or stressed in the last part, in the last column, the light blue one. And this is an horizontal assessment of problems that I could pick up and detect looking at not only at the outcomes of the treaty compliance mechanism, but also at the recommendation that they make for the future. It is quite interesting, and this goes probably only with the Greco of the Council of Europe and the Working Group on Bribery of the OECD, that in the compliance and follow-up mechanism, they indeed produce soft law, and they actually monitor whether states have or not included or comply with or follow those recommendations. And you see some outstanding issues here. Effectiveness is lagging behind. This mainly due for issue of internal enforcement. There is a widespread underestimation of prevention, which is coupled with the horizontal recommendation of most of the monitoring treaty compliance system to invest in prevention, especially in the regulation of lobbies, in the investment in terms of financial investment of the anti-corruption independent units and so forth. You see a development of, this is my assessment at least, of suboptimal standards which do not advance existing acquisition. For example, the standard on whistleblower protections is significantly lower in terms of the guarantees that are established for the possible whistleblowers compared to the European Union directive in this respect. And then to me, there is an absolute in preparation of state to react to new challenges, such as, for example, party funding from abroad, or IT and the use of IT in the conduct of corruption. So my presentation was, I said, only meant to make a sort of common basis for our discussion. I am pretty much done, and I will leave the floor to our conversation now. And I know that the first two people, the first two speakers we present, they have much to say about the reliance on data and the rationalist approach as far as the fight against corruption is concerned. And I would like to first address Han van Aaken. Han, in your work, you address quite clearly the assumption that international law against corruption is mainly based on criminalization from a psychological perspective. And you also actually candidly convey that this seems to make sense because corruption is a white-collar crime, and anti-corruption convention assume then the self-interest of rational actors. But your paper shows that psychological insights, including from corruption fighting, inform about further additional deterring corruption, factors deterring corruption. And I would like to ask, first of all, if you might elaborate a bit, might expand on your findings, and then, based on that, if you can explain us which kind of dimensions are missing to the picture, how your analysis or analysis like yours could impact the ways forward in combating the fight against corruption. Thank you very much.
Thank you very much, Leonardo. Can you hear me? Yeah, okay, so thank you very much to you, Leonardo, for organizing all this with such diligence, even if there are some technical glitches which are clearly not your fault. So I try to share my screen and I hope it'll work. Can you see it? Yeah? I can't hear you.
Yes, we see it.
Okay, perfect. So, so Leonardo has already said what I took out my first slide because we are permitted very few slides. So I don't even put the title, but what I'm looking at whether psychological insights or behavioral economic insights can help us in the fight against corruption. And as Leonardo has already said, corruption is a white-collar crime. And what we usually say is that, well, if we have white-collar crimes, then we can apply rational choice analysis. And international law tackles this problem basically by putting on a cost-benefit analysis of corruption, taking a repressive approach. And you find that in all of the treaties, the criminal law section is really the biggest section, even though AMCAC does have a preventive section. So I think it's safe to assume that underlying this is a rational choice approach to crime fighting. And what I argue is that this is really just the tip of the iceberg. And that is, and this is necessarily a starting point. And I'm not saying we don't need to discard it. It's there and we need that. But the question is whether it is sufficient to understand what's going on, given that the fight against corruption has not been especially successful. So I give you those slides here, and I took the photo of those posters in the Ministry of Justice in Ethiopia in 2005, where I was teaching, and I found it very interesting because what it shows you on the poster, corruptors end up losers, is really saying, well, you made the wrong cost-benefit analysis. It really comes down to the self-interest of the corruptor, whereas the second poster, where it says corruption is a social evil, really goes to the motivation of...
Can you, sorry, can you show
the slide? The slide didn't move forward here.
Okay.
We're still at on the iceberg slide. That's a typical problem, of course.
Can you see this one now?
Now we don't see any more slides. We don't see any. We see you.
Oh, okay. Great. Okay, let me try to, let me go down here. So this is difficult, especially with the time. Can you see that now?
Yes.
Yeah,
okay. We see.
Okay, so those are my favorite posters. On one, you see corruption is a social evil, and it really comes down to say, well, this is not only about an individual cost-benefit analysis focused on self-interest, it's really also about other motivational factors and preferences of people. Can you see my next slide? Well, you don't really need to see it. I can just read it. So I was really happy that like 3 weeks ago, there was a UN guidance on behavioral science coming out, and there is a quote by Antonio Guterres who says, behavioral science is a critical tool for the UN to progress on its mandate. It can contribute to combating poverty, improving public health and safety, preventing and managing crisis, promoting gender and economic equality, and here, that what's important for us, tackling corruption, strengthening peace building, and all the SDGs. So what's the point here is that UN has finally woken up to behavioral sciences, and it is meant to be using them, including in the fight against corruption. So what are potential ways forward? And let me have some very few preliminary remarks before I come to my main slide. And in case you're not seeing it, I will again stop and share again. So fighting corruption is really a multi-level endeavor on the local, the national, and the international level, and the transnational level. It's also a multi-actor endeavor. Now, you could ask, well, what does it have to do with international law? And as Leonardo has said, I think by now we're at a stage where we also need to look at soft law, at recommendations. especially also on the prevention side, and that can give directions, and it's best done at the international level. But clearly the devil is in the detail, and also recommendations depend very much on the type of corruption. So whether you have petty corruption or political corruption, and what type of political corruption. So there has been a lot of research on that, and all that needs to be taken into account. Can you see my slides or not? Can you see the pyramid?
Yes.
Okay, perfect. Then I put this in big because that's okay, so what I try to do here in my paper, and actually I can't talk really about findings yet because it's a very preliminary draft, but that would be the way for me to go forward and to get a more holistic picture. So what you see in the red triangle is really what we are doing now. So we assume rational choice on the individual level, and we work on deterrence and external sanctions. So the little very actually simplified what you see here is that, like, if you will have a corrupt act if the benefit is higher than the probable costs. So if we move to behavioral economics, which again is on the individual level, which is the middle level you see here, we usually think about two deviations from the rational choice theory. One is cognitive and one is motivational. And on the cognitive part, what has been, I think, a very secure finding is that people act according to prospect theory. So their loss is felt more deeply than a gain. A gain is, so you lose more from utility from losing $100 than from gaining $100. It's felt more acutely, but in the loss frame, people are also more risk-seeking. So if that is true, and you want risk-averse actors in the area of corruption, then you would need to focus on gains, so the benefit of corruption. This is probably also usually the case because people, when they are taking part in corruption, then they usually focus on the gains from it. The issue is that if the probability of being caught is low, then you have a reverse. So, which indicates that you need to work on the probability of P, now of the probability of being caught. Now, that is easy to say because we know that the probability, given that it's a secret crime, is very low anyway. So what we can do is work on the availability, for example, saying, having more of a public announcement of investigations of crime, of convictions, and putting it into the public sphere. The same concerns over-optimism. People tend to be over-optimistic whether of being caught or not. And here we can work on the costs as well, on the cost variable. Let me turn to the motivational part. And so all this is very, very superficial, and all this is just tackles few examples. There's much more to it. Now, on the motivational level, we do know that fairness and other regarding preferences are present in people. Values are important. And that, again, is just an example. Anke was really is vocal in talking about victims of corruption, and I think that ties in also to Anne's paper. But that's not enough. It's also not enough to say that so many people do not have, let's say, access to education or healthcare, or buildings break down. You have to show the victims. That again would impact the cost variable in the equation, in the sense of that you hire the costs, the moral costs of corruptors, and that I think is important. All this just gives you examples. And why is it important to show the victims? Because we know that we have there's this psychic numbing phenomenon. If you tell people 100 people have died and drowned in the sea, they will usually not care very much. They care much more if they see one victim. So those are very known psychological phenomena, and I think we need to take them into account. Let me quickly move to the last part, which I feel is underlying the problem of corruption in many countries, and that is the culture of corruption. So that comes back to the question of narratives of corruption. And, you know, it's interesting, Leonardo, you said that it was always seen badly, but then the question is, again, what exactly we do see as bad. And I lent here from Susan Rose Ackerman in her 1990s article on gifts and bribes. A lot of what we say now are bribes were used to be seen as gifts, including in Germany, and I can tell you some anecdotes about it. It was pretty normal to have pretty big gifts for Christmas, for example, including between private firms, and that was seen as totally normal. It was fine to have to give your professor a bottle of wine. Now, I wouldn't accept it anymore, but at that time, 20 years ago or 30 years ago, that was pretty normal. So all those things, there's some shift seen here, but the important thing is that those narratives change very slowly. So much less, you know, it's easy to have a criminal norm against corruption or work on the sanctions you are giving, but it's much more difficult to work on the culture of corruption and the narratives. It also comes back to the function of international law here, and if we take an expressive law approach to international corruption fighting, I think what is important is that the expressive law theory would tell you, even without sanctions or low probability of being caught, there is an expression of what is bad and what's the focal point of behavior, how we should behave, because there was a lot of uncertainty of how exactly people should be behaving. And then the last thing I want to mention is really trust and reciprocity. Reciprocity can go both ways. Reciprocity is really one main stage of human societies and how they coordinate, how they cooperate. And reciprocity, if you break it down to corruption, can be good or bad. So reciprocity is very good in between the corrupt, because there are always two corrupt people or actors. So if they have trust and reciprocity, that's very good for them because it stabilizes their corrupt relationship. But on other issues trust between principals and agents in an economic speak, so for example, between the CEO of a company and employees, or bureaucrats and citizens, trust would be important to fight corruption. Now, why are behavioral insights important? Let's take the whistleblower recommendation. Whistleblowing would be fine, you would say, and I think I stopped sharing here, so I see it's terrible to just speak against the okay, can you see me now? Okay, against the screen only. Whistleblowing would be an example where you could say, well, it depends, because we do know that we have societies which have strong antisocial punishment. So people who are whistleblowing will be punished. So no matter how good you make the whistleblower protection, there will be social punishments against them. So it's really, it's amazing what has been found. Greece, for example, has a very, very strong tradition of antisocial punishment. So if you're a whistleblower in Greece, you better leave the country. Okay, whereas in other countries, that's not that strong. So it really depends on where you use it. And I think the law needs to be attentive to those sort of insights. It's highly complex, and I think that already leads over to Kevin's talk on the caution, even though I'm applying it, and I think we need those insights, we need to look at them carefully. There are limits to that. Maybe it's an experimental approach, whatever works best in each country, but clearly is what we have done so far is not good enough. Okay, So the only thing I want to do is maybe give some sort of additional tools and ways of looking at the phenomenon of corruption and embed it into the law, because economists have been working ever more from a behavioral perspective on corruption. Lawyers tend to overlook that, and I think that's a mistake. Thank you very much.
Thank you very much, Han, for this experiment that you, enlightening experiment that you drew us in, and it's indeed enlightening also for how to reshape possible new responses, or since soft law is more flexible, is easier. We might also think that we will have margin to use behavioral economics to advance the current normative framework, and I am honestly and genuinely extremely interested in seeing the developments of this issue. As you were mentioning, Kevin, I don't see Kevin anymore. Kevin, are you online?
I'm here. I'm here. Can you not see me?
Okay, you are. We cannot see you, but we can hear you. I mean, this seems made on purpose every time.
Can you see me now?
Kevin, you were online. No, you were online the entire. I mean, they are really boycotting it.
I didn't do anything, so can you still hear me though?
Yeah, that's the most important.
You see the video icon, the camera icon is yellow or green?
Yes, it's green, and I can see myself, which is the puzzling part here. So I see myself alongside all of you.
I'm extremely sorry for that. I don't really know, Kevin. You should refresh the page. The online assistants suggest that you refresh the page. Now Kevin is dead. He's really out of our panel.
Or we can simply listen to him if we cannot see him.
Okay. Wow.
Yep.
We are in again. Thank you very much, Kevin, for bearing with this IT platform, with which apparently we all having some issue. Anne actually mentioned about your research, and indeed in your paper, you argue that the prospect for an evidence-based regulation of transnational bribery is limited. And on the other hand, you consider inclusive experimentalism as a valid alternative approach. Then I would like to ask what are the most significant obstacles to the adoption of an evidence-based approach for the regulation of transnational bribery, and then, of course, to what extent do you believe that the alternative to evidence-based approach might be reliance upon biased judgment, which leads to the last question of whose judgment we should count on.
Okay, well, thanks. I guess I should back up though and explain what I'm referring to when I talk about an evidence-based approach, right? And to me, the question, which for me is still at the top of my screen, the sort of title of this panel, 25 years since the conclusion of the first International Anti-Corruption Treaty, what has worked and what has not? That question is premised on the idea that we want evidence of what works, right? And I think it's important to recognize that the kind of data that you presented at the very beginning, Leonardo, of, well, what sort of legislation have countries enacted in response to the adoption of the treaties, or what sort of anti-corruption agencies have they created, that isn't necessarily the kind of evidence that we care about when we pose that question, what has worked and what has not, when we're talking about anti-corruption treaties. Because I think the evidence most people would care about is, well, have these treaties worked to stop corruption, right? So when I talk about an evidence-based approach, I'm really saying, well, you know, when you're assessing the effectiveness of these treaties or evaluating these kinds of treaties or even international legislation, we should care about the evidence of their effects, their outcomes, and the outcomes that we care about, right? In this case, corruption. Okay, so with that on the table, if we think about what steps you have to go through to try to provide evidence of what's worked. Well, what social scientists do is, first of all, they collect data, right? They collect data on the intervention. So here's a treaty. It came into force at such and such a time in these countries, right? So you've got the intervention on the one side, and then on the other side, you've got the outcome, data on the outcomes. Here's what happened to levels of corruption in the particular area covered by the treaty, right? So step one, collect data on those two types of variables, right? The next step is to try to connect them, right? To figure out whether there's a causal relationship between the adoption of the treaty and, let's say, a decline in the level of corruption, or possibly even an increase, right? So that step of causal inference that's basically what the social scientists do with their regressions and so forth. And I think as lawyers, I'm assuming most of the people on this call and so forth are lawyers, we sort of rely on them to do that, but it is an important step, and it's difficult, and they struggle with it, right? And we should question their efforts to draw causal inferences in this context, because they don't necessarily specialize in drawing causal inferences about the impact of legal interventions, right? Okay, so step two, the causal inference. And that's all about telling you what's happened in the past. I think often when we ask this question, what has worked in the past, and have these treaties worked, we're asking the question to try to figure out what to do going forward, right? So often there's a third step, which is to try to generalize from what's happened in the past to figure out what to do in the future or in a different context, right? So in the paper that's the backdrop for my participation in this conference, I talk about that question as well. How do we go about generalizing, right? Okay, but the first two steps are the really key ones, right? The collecting the data and drawing those causal inferences. And those, I suggest, are actually very, very difficult when it comes to anti-corruption law, right? We have pretty good data on the law, the legal instruments, right? The legal text. We certainly can find the treaties. That's not so hard, right? And we can usually find the legislation that's been enacted in response to the treaties. There's an intermediate step, though, which I left out in my overview, of figuring out, well, how are the laws being enforced, right? And for all the reasons that Anne van Aaken was talking about earlier, we care about the level of enforcement, who's being targeted, how the laws are being publicized, and so forth. And data on those types of enforcement practices are actually very difficult to come by, right? We know about successful enforcement actions in the United States and maybe the other parties to the OECD convention in foreign bribery cases. We know about that, right? We have good data on enforcement in that sense. We don't know much about enforcement against the officials, the public officials on the other side, which often happens in their national jurisdictions and doesn't necessarily occur at the national level. It could be at the subnational level, and it could involve non-criminal sanctions as well as criminal sanctions. There's a lot of missing enforcement data there. And there's also just even on enforcement outcomes, and we know even less about enforcement effort, right? How many resources were allocated towards enforcing these conventions? What quality of resources, right? How well trained were the investigators? Did they have accountants, forensic accountants with them, as well as lawyers and so forth? So there's a lot that we don't know about just how these treaties are being enforced, right? And then, of course, on the other side, when it comes to the outcomes, we know even less. We have really bad data on the level of corruption, right? And that's in part necessarily true, because people who engage in corrupt behavior are trying to remain undetected, right? So I'm not criticizing anyone here for lack of effort. It's just the nature of the beast is it's going to be very difficult to measure the prevalence of corruption in any given place, in any given time, in any given sector, right? And so that makes everything we do to try to collect evidence suspect, because all we've got usually are these perception measures, right? Which I've spent a lot of time writing about the weaknesses of these kinds of things. And in a few cases, what the situation is improving when it comes to sort of relatively low-level bribery, I'd say, because we have enterprise surveys or population surveys where we've asked people, have you paid a bribe and so forth. And that's actually an improvement. So we're starting to get better data on that front, but that doesn't usually go to the effects on the kind of bribery and large-scale misappropriation of assets that is the focus of the international regime, right? So we don't have great data on levels of foreign bribery, sort of grand corruption of the sort that's, I think, the focus of UNCAC and the OECD convention. So that's a big challenge, right there, to answering that question. Has this worked, right? Then, of course, there's the question of causal inference, right? Even if we see trends, okay, jurisdictions have enacted laws, we have a general sense of how much enforcement is going on, and maybe we have a sense that perceptions of bribery, of the level of bribery, are pointing in the right direction. Does that tell us that there's a causal connection? I don't think we know that. There's no way to be really confident about that at this stage. Part of the problem is the sort of overlapping nature of it and multi-level nature of this regime, right? You've got the international treaties, you've got lots of different jurisdictions that have overlapping, or lots of different countries with overlapping jurisdiction over particular offenses. So if we see bribery, let's say, declining in Nigeria, we don't know if that's because of something the Nigerian government was doing, right? Or if it's because of what the UK government was doing in foreign bribery prosecutions or in money laundering prosecutions, or is it because of the Americans? Or is it just because of changes in the level of Chinese investment? Who knows, right? So drawing those kinds of causal inferences in contexts where there are multiple causal factors, both legal and non-legal, is a real challenge. And it's one that social scientists aren't really focused on because it's, I think, specific to the task of drawing inferences about the impact of legal interventions in these in the context of multi-level governance, right? And that's not what a lot of the economists or financial economists are doing day to day, right? So I think those are two of the main challenges to answering what, again, is a really important question. Is it working or not, right? But it's a hard question to answer, right? I'll just say two other things about the challenges. Certainly, there's a sense that we also should be drawing lessons from what's worked in the past for what to do in the future, right? Say with whether or not at the more micro level, things like, well, should we follow the US approach to foreign bribery enforcement with granting leniency to people who self-report and so forth? Has that worked or not? And you can imagine doing some sort of study on whether the DOJ's leniency policy, the US Department of Justice's leniency policy is actually worked in some sense, right? Let's imagine you've got a study like that. Even if you have a really good study of that sort with clear results, it's not obvious what you do with it if you're sitting in the UK, right? Or in Germany and trying to decide whether to adopt a similar approach to enforcement. The problem of generalizability is a real one and a significant one, right? Or the external validity, if you like, of the study is that's something we're still struggling with. And then the last thing I'll say is the overarching challenge in many jurisdictions is that it takes a lot of expertise to design a good study and then interpret its results, or even to interpret the results of other studies. And that challenge of finding the institutional capacity, right, to adopt and implement an evidence-based approach is one that I think the international community and governments generally need to pay more attention to. So if the question is not only what is an evidence-based approach and why does it matter, but also what are the obstacles to implementing it, I'd say it's the data, the problems of causal inference, and then in many contexts, generalizability with this overarching concern about where do we find the capacity to try to make some progress on this task. So I think that was your first question. Maybe I should pause there and see if you wanted to follow up, because I know you mentioned a second question, and usually the next question is, well, okay, if you're so pessimistic about this, what are we supposed to do? Can you be more constructive? So I can get to that, but let me pause and see if you wanted to follow up there.
I would suggest, first of all, thank you very much for your deconstructive analysis of what we had at the table now. I would like just to modestly make two suggestions. First of all, of course, if you take the data that I show, or the data of the monitoring compliance of the treaty mechanism, you assume the perspective of that system of governance. And I don't really know whether this is right or wrong, but what I can say, being involved also personally in some of those treaty monitoring, is that some of the data you're looking for are in the report, especially in the last rounds of report of the Greco and the Working Group of Bribery, where they actually look at, for example, how much a certain prosecutor office was funded, how this could be related to, to the length and the complexity of international investigation and so forth. So I do agree with you totally that we need data, but some of the data are there. I also agree with the fact that we have, the social scientists doing a great job on that, but they also have struggles in coming up with a causal relation. I wrote my book on corruption with an economist of the IMF, and the first thing he made it clear was that what you can find at the maximum is a positive correlation between the main economic variables and corruption, because too many other factors impact. So I think that having a positive correlation, again, insofar as we become better and better in measuring corruption, because that was the other point that you made, and you're totally right, is a good issue. For the last part of your question, I mean, I'm not very, let's say, impositive moderator. I'm not able to do that. I'm no moderator, actually, to be honest. So I will also ask to our other panelists, because what we can do is to shift the second part of your question. I mean, the let's say the past constraints to the question and the session, which we should have in terms of time, and that will also, probably let us to conclude with a more optimistic view this panel. What do you suggest? What do you think about that?
No, that's fine by me. And I just want to thank you for pointing out that those reports, those monitoring and evaluations actually do contain a lot of data, and but it's in qualitative form rather than quantitative form.
Yeah,
so
I try to reduce that in my elaboration in quantitative form, but then you have to make a number of informed judgment, and sometimes they can simply say, you said that it's too partially compliant. For us, that was completely compliant. So there is always a margin of subjectivity, but if you want to work on that, I mean, there are possibilities to. Okay, I thank you very much for your really analytical, deconstructive interaction on what we have at the table now, and how we should, reframe our way of thinking to the new, way forward for corruption. I would like now to change a little bit the angle and to stick on to what we have in terms of treaty law, probably the grounding novelty of the UNCAC. Since we mentioned the UNCAC, all of us mentioned the UNCAC, was the chapter on asset recovery, and I am particularly familiar with the chapter because I myself was involved in some of technical assistance mission in some countries for the repatriation and then for the management of these of the assets or the proceeds of bribery that were repatriated. But what we can say is that the defective part of the process of the asset recovery cycle is indeed in the management part. And actually, to me, at best of my understanding, no scholar so far as, at least no legal scholar, has tried to investigate this aspect. But Cecily has started to do that, and I'm very, very curious to see what Cecily has to do, what Cecily is doing on this respect, and specifically, I think that she will help us in having a pragmatic grip on what is going on and the way that the process can be improved. So, Cecily, I thank you again for being with us today, and I would like to start by asking what types of problems tend to arise in the practice with respect to the recovery of assets and specifically to proceeds of assets, and then to what extent the existing treaty law address or provide any sort of basis solution for the problems of asset management, and what are the possible improvement that we might speculate about, even in the dialogical dimension between the international law and the domestic legal jurisdiction. Thank you very much, Anna.
Thank you very much for that introduction. Well, I think my remarks will, I hope, nicely complement what Kevin has just talked about, because I think here in the asset recovery context, we really don't have a sufficiently developed sense yet of the extent to which the provisions that exist are helping us solve the problems that exist, because we don't have enough information about what is actually happening. So we have the UNCAC review mechanism, which is still in the process of reviewing Chapter 5 of the Convention, which is the part that deals with asset recovery. We also have research by the World Bank on this issue, which is ongoing. And we also have a World Bank database that's incomplete. So I think there's a lot that we still don't know about what's happening on the ground. So I'll just speak on the basis of what I do know then. So first, we know, for instance, that there are problems about who receives funds that are returned. So there are questions about how victim populations should be prioritized, for instance. So not only who should receive the funds, but also whether it should go into a general account by the receiving state, or some sort of special fund that allows, for instance, for better tracking of how the returned assets are spent. And there's also, I think, questions about the practice of non-governmental organizations acting as the recipient of funds that were stolen from the state of origin, and whether this is a good thing and how it should be regulated. And then I think there's also questions that are outstanding about whether there should be different norms governing recipients of returned assets in the context of embezzlement cases as opposed to bribery cases. So in addition to those questions about recipients, we also have the question about what's actually written down on paper, and if there is anything written down on paper. So what we see, for instance, is that in many cases, apparently, according to the World Bank, there is no written agreement governing the return of stolen assets. That's quite a striking fact. And then where there apparently are written agreements, often they're not published. So the practice of the United States, for example, is to issue press releases without, and in some instances, there are indeed memoranda of understanding that are published as well. But I have extensively researched this issue, and I have come up with probably about a dozen memos of understanding between the state that is returning the funds and the state that is receiving. So that's very little. The next, I think, major issue is how then the re-corruption, essentially, of funds that are returned. And this may be the issue really that's the highest in terms of urgency or priority. Now, from a good governance perspective, monitoring the return of funds is a basic precaution, especially in countries where large-scale embezzlement or misappropriation has taken place. But there are lots of outstanding questions about what the best practices should be with respect to monitoring. And so who should be engaged in monitoring and how should they go about it? And then I think that we also have finally questions about disputes that maybe arise between the haven state and the state of origin, and how those ought to be resolved. So I'm going to switch now from having described some of the basic problems in very broad terms to talking about briefly what the treaty actually provides, which is actually very little. So with respect to the issues that I've just noted, the key provision is Article 57 of the UN Convention, and This provision imposes an unqualified obligation on requested states, that is haven states, to return confiscated property to the requested state, but only in a very narrow set of circumstances, which I won't go into right now, but I'm happy to elaborate later if that's of interest. So in quite a number of situations, those limited conditions won't be met, such that there isn't actually an obligation to return confiscated assets. Even where an ownership claim exists on the part of the state of origin, where they are public funds that have been misappropriated or embezzled. Now, Article 57 also doesn't require the conclusion of any sort of memorandum of understanding. And it doesn't require the prioritization of victims or recipients in any particular order. So what I think it's fair to say about UNCAC is that it was the product of a compromise at that time. And it was an accomplishment given I think the big gap between developed and developing countries during the negotiations in the early 2000s, but it still leaves a lot to be desired. And so in terms of the way forward, I have lots of ideas about how norms on asset recovery could be further developed. None of those ideas really, though, involve working within the UNODC or UNCAC system, because I don't think that's going to be the most productive way forward here. So, for example, I think that treaty amendment is not really a realistic option here. It could be that states parties to UNCAC through the Conference of States Parties could develop subsequent practice or subsequent agreements governing these issues. But I'm skeptical about whether that's likely to happen given the institutional culture within UNODC and the fact that there hasn't been any really significant movement towards doing that, at least not to date. So then what we have now is various domestic solutions that appear in legislation, as in Switzerland and other countries. And we see a range of approaches, some of which I think are problematic. So I think there are, for example, problems with funds being returned by a haven state to the haven state's development agency for expenditure in the state of origin. So I think there are real questions about whether that's an appropriate way to handle the return of stolen assets. There have also been, it's important to say, some international initiatives that have produced principles that govern asset recovery. And I can elaborate more on this later. But I'll just say now that none of these principles really, in my opinion, delve into these questions that I've outlined with any sort of sufficient detail. Now, my last idea is that, which I would be curious to hear your views on, is that I've noticed, for instance, that regional trade agreements sometimes include anti-corruption chapters. And those anti-corruption chapters tend to just reproduce what's in UNCAC. And isn't that actually an opportunity to progressively develop the law here? Maybe to use the regional free trade agreements as an opportunity to perhaps include some progressive provisions on the management of returned assets between the parties to the free trade agreement. So anyway, those are my thoughts for now, and I look forward to hearing your views.
Cecily, thank you very much. I would like to address many of the points that you raised. It's super interesting, especially the last one. I am on the one hand, let's say, sort of inclined to think that there would be a good path to develop a progressive, set of norms. On the other hand, at least bilateral trade agreements and also, some regional trade agreements tend to have no enforceability. This will have to do very much with the to do with the development of the World Trade Organization and the appellate body specifically. Contemporary trade and investment treaties is one of the part, of course, that we did not mention at the beginning, saying that corruption has mainly been dealt by international criminal law treaties, but these are actually tools that address corruption as well. As much as it is, human rights law, at least in terms of normative perspective, I would say that the link between corruption and human rights violation is not longer confined only to the preamble of well-known anti-corruption treaties, but scholars, but mostly international organizations in their policy paper have been investigating such link, and a debate about conceptualizing corruption as a human rights, is still ongoing. So we all know that Professor Peters actually had addressed some efforts in this issue, and I would like to put it very crudely. What Anne have elaborated in many papers, meaning that there seems to be a negative feedback loop between the countries which are perceived as highly corrupted and countries that have a poor human rights record. So, Anne, without further ado, I will leave the floor to you, and I will ask you, what is the proper legal, or if human rights law can be a proper framework to denounce and combat corruption, according to your opinion, and also what is the quality of the assumed link between corruption and human rights violations for both a positive and a normative perspective, because this is what actually you specifically address in your paper.
Thank you very much, Leonardo, for hosting this panel. I hope you can hear me. Okay. I am, of course, aware that both Cecily Rose and Kevin Davis have voiced strong skepticism against the utility of the human rights-based approach to corruption, but I would like to still defend it. And I put in the public chat, I put two recent empirical studies which show a significant and positive correlation between the perception of corruption and human rights violations. So that if one decreases, so does the other. I here quoted the study by the Mexican group of researchers, Cardona. And of course, I'm aware of what Kevin elaborated, that the measurement of corruption is very poor and that we rely on the perception mostly, with all the problems associated. So these two studies claims rely on these maybe flawed starting points, but they detect a significant and positive correlation. And because there is this, so to speak, vicious circle, one could say, I think that human rights are an appropriate complementary framework to the otherwise mainly criminal law-based approach to combat corruption. The study by UNDP, or commissioned by UNDP, conducted by Sergiu Ostaf on Moldova, published in May this year, found that corruption impacts the most vulnerable and marginalized, such as poor households, women, socially disadvantaged, and so on, and identified 5 frequently impacted rights for these groups: right to life, right to legal counsel and fair trial as the most frequently affected, right to education, right to health protection, and right to private property. So both social rights and political rights are affected. When I say that the human rights approach, or the human rights framing, has advantages, I think that the main difference to the criminal law-based approach is that, of course, criminal law focuses on the individual perpetrator who will be sanctioned by criminal law, whereas human rights are addressed to the state, and the human rights violations address the state. That's, of course, a crucial difference. Now, Leonardo, when you ask for the legal quality of this assumed link between corruption and human rights violations, then I would first like to give you some more data and examples from the Moldovan study, which I put in the chat. the study looked at 1,000 cases drawn from agency databases, for example, from the Integrity Agency, from the Ombudsperson, and so on. And they found that a third of these 1,000 cases contained a direct corruption effect on the human rights violations. And they identify 3 types of human rights violations. First, human rights violations resulting from an individual corrupt act, which is not yet evidence of a systematic pattern, which they call type 1 human rights violation. For example, if a teacher asks for a bribe, student refuses to pay the bribe and receives a lower grade. Then second type is human rights violations resulting from individual corrupt acts and a faulty implementation setting. For example, in Moldova, inhumane prison conditions. Apparently, the law says, or there are regulations to say that the pretrial detention should be calculated, and the penal law requires a different calculation for situations when the prison conditions are inhumane. But officials discriminate on the basis of ethnicity, for example, against Roma, and the prison direction tolerates this. So it's both individual human rights violation plus faulty implementation setting. Type 3 violations of human rights are additionally with flaws in the policy instruments or in the laws. For example, domestic violence. The aggressor bribes the police officer doesn't properly investigate the case. The systemic aspect is that the norms of the criminal code and the administrative offenses code allow discretion for the police. So this is the systemic concept which facilitates the human rights violations. So now the doctrinal questions which arise are, first of all, when can we speak of a human rights violation as opposed to only a negative impact or an environment conducive to abuses? Here, we probably must distinguish between systemic or grand corruption on the one side, and we need a different analysis for individual cases of corruption. And as you know, of course, from a human rights perspective, there are 3 obligations of the state, or 3 dimensions of obligations, namely the obligations to respect, protect, and fulfill human rights. And if we now go back to the 3 types of human rights violations, which I mentioned, then we can see that individual official acts, their acts or omissions, they can interfere with all 3 dimensions of the human rights. And the behavior of the individual official will be attributed to the state as a whole. Also, if, of course, one could say that the corrupt behavior is an ultra vires action, if it is under cover of law, which is, I think, mostly the case, because the official can, of course, give a license or refrain from prosecuting domestic violence and so on, so to do the service only under cover of his public authority. But if we look at the type 2 and type 3 violations, which are normally called grand corruption, then what is at stake is the state obligation to protect against individual human rights violators. And in that case, the individual officials are, so to speak, the aggressor, against which the state should, through systemic measures, better laws, better enforcement, and so on, protect the victims. Some other aspects are that it is very difficult to identify a violation of the social human rights, which are codified in the International Covenant on Economic, Social, and Cultural Rights, because, as you know, here the key obligations are only the obligations to progressively implement, to take steps, also softened by the availability of resources. So the whole concept of violation is not clear for these rights in that covenant at all, because there is a certain lower threshold which only allows us to speak of violations. So that's one big problem for the social human rights. And then it was already mentioned by others, of course, we have the big problem of causation, but the legal concept of causation is, of course, something different from the social science causation. but here, the whole concept in international law and also in international human rights law is very underdeveloped. There are some buzzwords which are used, for example, proximity and foreseeability and so on, but there is quite little case law. So a lot of work would have to be done to flesh out more causation. And in closing, I would like to come to the normative aspect, which was, I think, mostly attacked, for example, by Cecily and by Kevin. Should corruption be conceptualized as a human rights violation, even if we can't technically do it? What's the added value? Does it make sense? And what are the risks? And the risks are, of course, that the whole aversion against the anti-corruption agenda, which is, as we have seen in the talks before, also it's so much based to the 1990s, and it is perceived by many increasingly, I think, as a hype, as a crusade of the West, of an imposition of a neoliberal state model, which is also accompanied by a strong distrust against what's now called by critical voices, human rightism, overstretch of human rights overreach, human rights bloating, etc., etc. So is here a systemic problem artificially forced into the human rights mold? And is the framing only strategic in order to reach the courts? Because, of course, only there are no, the anti-corruption conventions suffer from very weak enforcement, and on the international level, with regard to human rights, we have at least some courts available. I think that the critique against using human rights at all as a frame is not convincing, because there is this real positive association, this real negative association, this vicious circle. So it is a matter of a legal fact, so to speak, that human rights are violated and that the violations are associated with corruption. So it would be also blinding oneself to this dimension of the law, leaving out the human rights analysis, which bears some opportunities, I think, namely involving the systemic responsibility of the state, which I mentioned already, and also the shift from repression to prevention, which is, of course, also a bit in the anti-corruption conventions, but which is stronger if we look at it through a human rights lens. And a third practical advantage is the shift of the burden of proof, because in human rights law, the state must exonerate itself, whereas in criminal law, of course, we have the presumption of innocence, so that the victim has to prove the wrongdoing. With regard to the practical consequences, I only want to mention that with regard to Moldova, this UNDP Commission study recommended a legislative amendment that would introduce corruption as an aggravating factor when determining state liability for human rights violations. And concomitantly, it asked for a similar amendment for considering the human rights abuse as an aggravating factor in determining individual criminal liability. And on the international law level, I would like to mention the recent document of the Inter-American Commission on Human Rights, document 236. It was published in 2019. It's only in Spanish. And it describes how the Human Rights Commission, it lines out in detail how the Commission will integrate corruption into its work. For example, in the monitoring mechanisms, the Commission has determined to integrate in all monitoring and in all thematic and special reports the corruption perspective. And it promises to give visibility to cases of grand corruption. And it will, in the petitions of individual petitions, it will, in the examination of the admissibility of the petition, the Commission will examine the context in order to determine whether the impugned action originated in a presumable act of corruption. So this is a firm determination and practice of the Inter-American Human Rights Commission. With regard to the universal human rights bodies, other measures can be thought of in the treaty monitoring bodies and in the Human Rights Council. So that overall we could speak, and I think that the work of the Inter-American Commission goes in that direction of a mutual mainstreaming of anti-corruption law and human rights law. And I would also argue that the human rights institutions do not overstep their mandate by doing so, especially as human rights-based analysis would be only a complementary approach, not a substitute to the criminal law-based approach, and could help a little bit close the the glaring implementation gap. Thank you.
Thank you very much. That was extremely thorough account, and also I think addressed some of the criticism that in the past was brought to the human rights approach on corruption. I hope that we will have time to discuss it further, but we're clearly running out of time. So let's move to our last contribution, Yarik Kryvoi, who actually will enlighten us on the different practice on international investment agreements and also international investment arbitrators as far as it comes to considering corruption in the, of course, in the last case, the investor-state dispute settlement. Thank you very much, and to you the floor. Without further ado.
Thank you very much, Leonardo, and I would like to thank the organizers for putting together such a rich conference and inviting me to be a part of it. My presentation is primarily based on two studies which I am currently finalizing for the UN Office on Drugs and Crime. The first study looks at FDI and corruption more generally and deals with anti-corruption provisions in international investment agreements, dealing with supply and demand, anti-corruption due diligence, investment immigration programs, and other topics. And just a couple of months ago, we convened a high-level meeting organized by UNODC and UNCTAD, examining corruption in the context of foreign direct investments with participants from states, businesses, civil society organizations, and so on. The second study is an empirical study which examines around 80 publicly available investor-state dispute settlement cases which involved allegations of corruption. So the second part of my presentation will be largely based on this study. We hope to finalize and publish both studies by the end of this year. And let me add that what I'm saying now expresses only my views, and these are not the views of the UN Office on Drugs and Crime. So when it comes to corruption in international investment agreements, in the old generation treaties, mentioning of corruption was very unusual. So it was mostly about protecting the interests and the rights of investors. There was very little about non-investment obligations. However, if we look at those treaties which were concluded in 2000s and later, there are more provisions dealing with and the slides are not dealing with it, but I will mention the slides when we will discuss the ISDS part of my presentation. So the new generation of treaties do include non-investment obligations, and they also include specific references to corruption instruments. Not all those new treaties include them, but they increasingly have these provisions. And I think I would group these corruption-related provisions into three categories. One is legal requirements. So essentially, the treaty, legality requirement, which essentially says that investment should be legal, and they also make explicit references to corruption. So if investment was procured using corruption, then it's not protected by the International Investment Agreement. The second category are treaties which mention anti-corruption as a part of corporate social responsibility. And they say that states need to encourage investors to follow corporate social responsibility, best corporate social responsibility practices, including dealing with corruption. And finally, some treaties reference the UN Convention Against Corruption or some other anti-corruption instruments without really discussing how those should apply in the context of international investment law. So the new treaties have not yet been tested by investor-state tribunals, but there were many cases where old treaties were tested. And our research suggests that since 2005, there were at least 7 or 8 cases every year where corruption allegations were made and where tribunals dealt with those allegations. And now the first slide, which you can see on the screen, not this one, but the next one, is an interesting finding. So our research suggests that it's usually states who make allegations of corruption. It's not investors who are saying, oh, the state was corrupt, but the states are saying, no, there was corruption. And why are they doing it? Because they hope to avoid jurisdiction of investor-state tribunal. And if there is no jurisdiction, there is no responsibility of states. So as you can see, in the vast, not in the vast majority, but in a more than 50% of cases, in nearly 70% of cases, states made this allegation. Let's move to the next slide. The next slide deals with the question of whether the tribunals actually deal with the allegation of corruption. And you can see that in more than a third of all cases, they simply ignored the allegation of corruption and they focused on other issues. However, in around 65% of cases, they did deal with corruption allegations. Let's move to the next slide. How about the success of investors and states in alleging corruption? So we can see that to the left, these are states alleging corruption. Sorry, investors alleging corruption. So to the left, I mean, let me refer to the figures better rather than to the left and to the right. So in 72% of cases where states alleged corruption, the tribunals actually did examine those allegations. However, in 48% of cases where investors alleged corruption, the tribunals engaged in discussing corruption allegations. So essentially, states look more persuasive when they talk about corruption. And one reason for that, to explain that, could be because they have more evidence to present so that tribunals actually examine allegations of corruption. Let's now move to the next slide. And here, another finding. So we found only 5 cases in a sample of more than 80 cases where tribunals actually did find corruption. And that means that it's very rare that tribunals find corruption. And in all those cases, the tribunal said that there was no jurisdiction over the claim. And in addition, they also reflected this. Some tribunals reflected it in the cost orders. So let's say if the state was also involved, then and was guilty, then they also reflected in the cases. Other cases also took more unusual approaches. For example, one tribunal instructed the state to make a contribution to UN anti-corruption fund. But since we don't have that much time left, let me move to my conclusions. So I think what should guide policy of states and the practice of investor-state tribunals is the principle that neither states nor investors should benefit from corrupt activities. Because very often, if there is no jurisdiction and both the state and the investor were involved, it's the investor who carries sort of the burden of negative consequences, and the state simply escapes the jurisdiction of tribunal of an investor-state tribunal. Also, I think there is more room to implement and to encourage anti-corruption due diligence mechanisms, and both for investors and for states, because it takes 2 to have, let's say, bribery and many other corruption-related crimes. So we shouldn't just focus on investors, we should also focus on responsibilities and obligations of states. Where the UN Convention Against Corruption is a part of applicable law, which is in most cases, adjudicators should examine substantiated corruption allegations, promptly report alleged corruption offenses to relevant authorities in accordance with applicable law. So this convention is like any other part of international law, is binding, and it should be treated seriously by tribunals. But the problem is that many tribunals are not aware of this convention, and only in 15 cases out of more than 80 cases they actually did refer to the UN Convention Against Corruption. And finally, where appropriate, tribunals should defer to domestic corruption investigations and await the conclusion of investigations not properly, because the tribunals themselves are not really properly equipped with corruption. So people who are deciding investor-state disputes are usually either commercial lawyers, or they could be lawyers specialized in public international law, but very few of them are criminal law specialists. I know that we don't have that much time, so let me stop here, and I hope that you will read the full paper soon.
Yarik, that was an excellent outline. I know that you have many more features that you wanted to discuss, but unfortunately we have this time constraint. Also, I must recall, for the benefit of everybody, that we have been the only panel allowed to have 6 speakers, and so I mean that would be at least to our credit and to the credit of the organizer. I see that there is a question from the public, but I also know that 2 of you, Van Aaken and Peters, you should go, you should go to Aaken. I mean, it's no secret. I'm sorry, and we basically agreed to stay on the 4:30. So I will try to give Professor Sacerdoti, Giorgio Sacerdoti, is not there anymore. Okay. So I think he probably raised his hand, like minutes ago, but we couldn't really stop our speaker at that time. I shut it down. I would very much curious to hear Kevin for the last part, but we have a problem with the time limits also, because we should guarantee smooth transition to the last part of the conference, and there is a keynote speaker by Peter van der Bosch soon. So I regretfully would like to close this panel now, unless there is any outstanding question from the audience, which seems not the case.
I can quickly address Anna's question about the standard of proof, if that's okay, because we did look into this issue, and the cases are all over the place. Clear and convincing, reasonable certainty, balance of probabilities, high standard of proof, you name it. But I think what can be summarized is that in most cases, I think in all cases, the likelihood should be more than 50%. So there's not one standard, but it's usually not just very simple, more persuasive or less persuasive.
Okay, I think Giorgio has written question indeed. No. Okay, I saw some question early on, but it was probably, it's here. There are a couple of questions for Anna van Aaken, and there is also a question I know you have already replied in the chat. Thank you very much. And then there is a question I cannot really see, and there was this question by Giorgio Sacerdoti somewhere. Now I think it's not online anymore. Which was about the next frontier in the fight against corruption, I think, but I don't really see the question anymore. So I don't know whether we have enough time to address Kevin conclusions, but Kevin, if you can be extremely essential, very concise, I mean, at least we can have the bright side of the story, and then I will simply, again, thank you all for this outstanding event. We had to face some technological issues that we would not expected. I mean, yesterday I made the tutorials and everything work. I'm so sorry for that. It's not down to me, but still I participated to that. And Kevin.
Oh, well, no, I don't want to take up any time. I'll just say thank you. The paper, there is a constructive part to the paper, which is I put in the chat where it's going to come out. And I'll just say that Ann Peters, although I was critical in some respects of the human rights frame, I think the frame itself is useful. I just queried whether all of the, say, the adjudication under the human rights frame is necessarily adding that much value. But thank you, Leonardo, and thanks to everyone else. This has been a real pleasure.
Okay, thank you. And let me add a collaborative note on that, since we were speaking about Peters or the criticism that the paper of Peters have raised. I have like two very short points. First of all, Han van Aaken actually rightly to me pointed out that it is not that we should actually show that there is some sort of cause also for the psychological shift of people in order to fight corruption. And this is something that economists have done. I mean, the book I wrote with Marco Arnone, I mean, we found a number of correlation, of strongly positive correlation, that the impact on public, expenditure, school, education, even on the measure. And this is something that could be integrated into this analysis, because it will give probably more grounds to. And the other point is just provocative, because Kevin, I was with you, like in the spirit. First seminar I was participating in the IMF. I just said, corruption perception index is just perception, and they told me, yeah, investment are perception. And the reply was, the economy is made out of perception. If you read, the underrated part of the theory of Keynes on the animal spirits, I mean, everything is perception. So I think that somehow we should also take this into consideration, because, we live in perception. I'm a kind of fan of Schopenhauer, and, there is something always between us and the external world. With this completely, sorry for this, probably, digression. I wanted, there is a book there on perception. Okay, thank you very much, Gabby. I would like to thank you, all of you, each and every of you, for the outstanding contribution. I hope that I was not the worst panelist or moderator ever. I try to do my best with the technical skills that I've been trained over this week, and I just hope that you did not find me too much pedantic on the preparation. I just forward the email from the organization. I will be in touch for our future project, and let me really thank you, each and every of you, for this outstanding panel. I mean, it's all yours, honestly. Thank you. Bye bye.
Thank you.
Bye.
Goodbye.
Thank you, Leonardo, for hosting that, and we'll be in touch.
Thanks, Leonardo.
Okay,
that was great.
thank you. Bye bye.
And narrative economics, I just posted it. Very good. Okay, Kevin. Yeah. That, of course. Okay, thanks so much. Bye-bye.
I have animal spirits, by the way, here, like second chef, like there. So so you see that we are all in the same loop. Okay, thank you very much, and wish you the best also for the remaining part of the day.
Yeah.
Okay, bye. Bye.
Bye.